reflected this notion in his opinion in the Gault decision, where he said, it would be a plain denial of equal protection of the laws and an invidious discrimination to hold that others could, because they were children, be denied them. The court has never decided a case on equal protection grounds, although being invited to do so. But as it turns out anyway, when the court does give children the same rights as adults, the children still end up getting less protection. For example, in Michael C., the court was only willing to assume, not hold, assume that Miranda applied fully to adjudicatory hearings. And they found that a 16-year-old undergoing custodial interrogation waived his Fifth Amendment right to counsel and against his prohibition against self-incrimination. And when Michael was told his rights, he said, I want my probation officer. And the police told him the probation officer was not available. They didn't say, he's not the one you should ask for, kid, you should ask for a lawyer, lawyer up. And Michael expressed concern that if he asked for a lawyer, the police would trick him by sending in a ringer, making believe that he was a lawyer. So the court held that the request to speak with a probation officer or any other trusted adult lay figure did not constitute a per se invocation of Miranda. And the court used the same totality of the circumstances test that were used for adults. And that test simply does not provide enough protection for children. Part of the problem is it's a standard, not a rule. So what does that mean? The different facts and circumstances, sometimes yes, there's a waiver, sometimes no. It's a test designed for adults with a wide range of experience and education. And what's interesting is that the Michael C. Court is deciding a Fifth Amendment question. One would think, wait a minute, there's a case on point here? The Gault case? Not even mentioned, not cited. Anyway, I couldn't believe it. I read the case over 40 times. I couldn't believe that Gault was not mentioned here. And then came Shaw in 1984. The court, which was somewhere over here, went back to pre-Gault days. The court upheld a vague and overbroad preventive detention law for alleged delinquents. And the provision allowed New York juvenile court judges to detain youngsters if there was a serious risk that they would commit a criminal act before the adjudicatory hearing. A serious risk, no guidelines, no nothing. More important, though, than the result was the court's reasoning. The opinion is peppered with aphorisms indicating diminished constitutional protection for children. We have to remember it's only due process they get. Children are always in some form of custody. The state's parents' patriotic interest in preserving and promoting the welfare of the child makes a juvenile proceeding fundamentally different from an adult criminal trial. Hello. And we need flexibility and informality, and perhaps the most dangerous of all, judges must exercise a substitute parental control for which there can be no particularized criteria. It was as if Gault had never been decided. 5? Okay. I'll talk fast. Okay. Okay. Now, I try to distinguish Shaw on the ground that the case dealt with a pre-adjudicatory aspect of the juvenile court. It's a detention hearing. Whereas Gault and its progeny addressed only the adjudicatory hearing. And although it's an accurate distinction, because of the Shaw Court's emphasis on fundamental fairness and children need to be taken care of and they have lesser liberty interests than adults, I'm not sure that the distinction is really correct in some real sense. With regard, now clearly it is showing its age, and not that I think it's going to be overruled explicitly. There are just so many cases the court can get rid of that way. But what the court can do, and does very well, is turning cases inside out until they are barely recognizable. Compare Gault to Shaw. And what in fact had happened is the court has now created 2 lines of cases dealing with the rights of delinquents, which gives the court enormous power and flexibility when deciding what to do in a delinquency case. The downside is, of course, fudgy law, uncertainty, and the appearance of dishonesty. I view Gault as simply a dishonest case. And this is happening in an era where states have increased penalties for delinquents in juvenile court systems. They've established extended and blended sentencing, and in fact, kids get convicted of very heavy crimes and are sentenced to 20, 30 years, not in a little kiddie playpen. It's the big time. It's in jail. And the states are waving younger and younger children off to the adult criminal. And the Supreme Court has never dealt with the constitutionality of laws like this. I want to take some solace from Roper versus Simmons. Ellen and I have had a major disagreement about this, but maybe I'm coming around to her way of thinking. In Roper, a 5-person majority on the court ruled that the 8th Amendment prohibits the death penalty for adolescents who commit capital crimes when they are under the age of 18. Note, a rule, not a standard. And the court relied, at least in part, about the emerging national consensus against the death penalty for children, and noted the international rejection of the death penalty. But more to the point, Justice Kennedy said, 3 general differences between juveniles under 18 and adults, they demonstrate why minors could not be considered in the worst class of worst offenders subject to the death penalty. And these 3 differences are the immaturity and irresponsibility of children, peer pressure, and perhaps more important, the transitory nature of a minor's personality traits, which is that children change as they get older. They are different. And there's a physiological basis for this, which I don't understand at all, and has something to do with white cell retrieval, which I think you will address. Roper, I would like to read. You notice I'm always an optimist. I'd like to read it, even though it's a death penalty case and therefore not a binding precedent in other contexts. I think Roper can be read as reinforcing